Okay, we're going to go ahead and get started. This is Dan Jaffe. I'm the CEO of LawLytics. Before going into tech full-time, I built and grew two successful law practices, the first in Seattle and then in Phoenix. During that time, I made some good marketing investments and also got badly burned. I experimented with phone books. I took out print in the State Bar magazine. I did a three-line print ad in the back of the Seattle Weekly, which is a weekly magazine, which was peppered with lawyer ads, calls for human experiment subjects, and adult entertainers. Um, I did a lot of different things and tried a lot of different types of marketing in a quest to understand what would work and what wouldn't. I built my first website in 1999, and that was in Seattle. And shortly after doing that, my business skyrocketed. In 2003, I hired a company which has since been sued into oblivion to do search engine optimization for my firm, and discovered their scam late one night after paying them what amounted at the time to about a month's worth of revenue in my practice. I spent a couple of sleepless nights removing their malicious code, and I was lucky that I had the tools and the understanding to be able to remove that because I got it out just in the nick of time. Because within days after that, all of their customers who weren't so lucky and didn't get all of their code cleaned up got banned by the search engines. That particular company folded under legal pressure, but the owners soon reopened under a different name and are probably still operating to this day. That experience, which made a big impression on me to say the least, started me thinking about what's real and what's an illusion when it comes to legal marketing. I wanted to know what kind of returns were realistic to expect. I wanted to discover a bright line rule that could tell me exactly when something was too good sounding to expect it to reasonably be true. It's as a starting matter here, it's really hard to find graphics that illustrate the points that I'm going to be making during this webinar. So please bear with me with these pictures. You're going to be seeing a whole lot of this guy. And throughout the course of this webinar. And the reason why is that Shutterstock, the stock image company that we use for pictures like this, has made this guy available in a variety of situational and emotional type poses. My point of using him in the various poses and phrases and phases is not just to have something different than just words for you to look at while I'm talking and you're seeing this PowerPoint slide. It's also to help illustrate the point that there is a lot of emotion involved in selecting and assessing how to spend your time and money to build your practice, and in putting a value on the returns that you get from those investments that you do make. Despite what the Supreme Court and the volumes of case law and ethics opinions tell us, legal marketing has been around as long as the legal profession. Part of the problem with the evolution of legal marketing since Bates versus the State Bar of Arizona has been that the technologies available, such as print and broadcast media, were static and provided no real opportunities for meaningful engagement, conversations amongst lawyers and between lawyers and potential clients, and most importantly, networking. Before Bates, networking was, like it or not, a form of legal marketing. You can call it anything you want, but that's really what it was. It was a way of business generation. The way that the internet is evolving, fortunately, legal marketing is returning to the old ways of networking, just in an updated technology and venue. And I have high hopes that it will help the profession of lawyering evolve with it. I personally think that the intervening years between Bates and the current state of online social networking that the technology has provided those years have placed a downward pressure on our profession. For years, the people who controlled the marketing, the salespeople, and not the attorneys have been in control. As attorneys, we had the choice of either playing by their rules or just sitting it out. The problem with sitting out marketing entirely is that the aggressive attorney marketers were then able to absorb much of the available business. Client getting is a zero-sum game. As lawyers, we really can't create demand like other industries can. We can't really invent new categories. We can't create needs, at least ethically. So, with only broadcast methods available until recently, the gambling lawyer who was willing to buy out the phone book, get the giant billboards and the TV and the radio time, got much more than what most lawyers would say is that particular firm's fair share of cases. And what happens, and I ask this rhetorically, what happens when lawyers get too many cases and they have to make a profit after paying their marketing overlords for those cases that are brought in? Unfortunately and obviously, oftentimes the clients suffer. Personal injury lawyers may settle cases that should be tried, opting for volume, sometimes against their client's true best interests. Criminal defense lawyers who take too many cases may plead out too many clients to charges that could have otherwise been beaten or reduced if they had had the time to actually be a threat to the prosecution. This certainly has a quantifiable cost to the clients. It also can be subjected to a cost-benefit analysis for the individual attorneys involved. I've heard some former big phone book advertising spenders, attorneys who rationalized that if they didn't do it, if they didn't buy that triple truck or that back cover or the inside fold-out pop 3-color, whatever you called it back then, somebody else would. And so there was really no true harm in them doing it. That vacuum of their absence in that advertising would get filled is probably true in most markets. But there always was a true harm beyond that to individual clients when the clients weren't served well because of high dollar, high volume marketing. It harmed our profession. It rewarded the biggest risk takers and deprived the best lawyers who were unable or unwilling to participate in the marketing charade. So even though I now run a company that builds software that helps attorneys market their practices efficiently, I'm squarely of the opinion that marketing since Bates has degraded our profession. I think the biggest harm came when we as lawyers ceded control over the information necessary to make informed decisions. The phone book salespeople knew this. Some of the large online legal marketing companies that employ armies of salespeople know this as well. As lawyers, we all have buttons that can be pushed, and the most common buttons are fear, pride, and greed. The phone book salesperson knew that if you make a lawyer feel stupid, he or she is less likely to debate you or to resist you. Once the salesperson got the lawyer believing that he or she is at a knowledge deficit, then fear or greed were used to close the sale. The problem with marketers and lawyers is that they play by very different sets of rules. The marketers perceive lawyers as fair game and largely feel justified in taking advantage of lawyers. It's kind of like lawyers are in season and nobody really cares if they get hosed. The marketers are not bound by any set of standards. They are largely unregulated. There are no rules of ethics that can expose them to professional discipline. There's no bar to entry in the profession. And it's hard to track them down after the damage has been done. In short, there's really no real accountability. Now, contrast that to lawyers. For lawyers, all of the things that I just mentioned are realities. They have rules that have to be abided by. And lawyers are used to playing by a set of ethics rules. And therefore, because they're used to it, they oftentimes project that and expect others to feel the same way and abide by the same set of standards. How many solicitations have you gotten from marketers who have said something like, we have a spot for you in our directory and it's going fast, or we have a lead who is hot to hire an attorney like you. If you're one of the first 5 people to respond, then this lead will be yours. How many of you have stopped to think as lawyers about the ethical or practical implications of a lawyer essentially buying leads from a non-lawyer when the lead never actually intended to engage that particular lawyer? If as a lawyer you don't see this as being problematic, if not per se unethical, then our profession is pretty far gone. Assuming that you do see the problem here, I can assure you that non-lawyer marketers don't see any problem with it at all. And that brings me to my first point. Lawyers and marketers speak different languages and use different measurement tools. Here's the definition of your return on investment in very simple terms from a marketer's perspective. This is a simple definition that takes into account none of the nuances of the legal profession, and by its nature is confined to a period of time. The only time frame the marketer cares about is the time frame during which they are getting paid. After that, the benefits or cost to you are irrelevant. For example, take the phone book, which comes out once a year. You buy an ad and you pay for 12 months worth of listings. Then the new book comes out and presumably replaces the old book and you stop paying. However, some consumers don't get the new books. Some throw them away. Some keep their old books. An attorney who paid for 12 months may still get more mileage from calls in the 13th, 14th, 15th month, etc., once they're done paying out the phone book and the new book comes out. Please note that this example is anecdotal because very few consumers of legal services still rely on printed phone books. Most of the phone books, that is, go straight into the recycling bin or get used as Kindle. But you get my point. Your marketing salesperson, being a non-lawyer and probably having never practiced law in private practice, thinks differently than you do. And here's what the typical return on investment equation looks like from a lawyer's perspective. This equation is obviously tongue-in-cheek. It's a way of saying that we as lawyers don't really have a unified, coherent formula that we can use. There are so many factors that are difficult to quantify. Some hinge purely on marketing, some on market forces. Let's start with some facts and figures. In 2013, United States-based law firms are projected to generate about $256.6 billion in revenue. Of that, somewhere around $50 billion is expected to be profits. The typical law firm with 100 or more lawyers spends somewhat less than 2.4% of their gross revenue on marketing. But the vast majority of private practice lawyers aren't in large firms. In fact, there's roughly 565,000 solos and another roughly 42,000 firms consisting of 2 to 10 lawyers. Moreover, firms of 1 to 10 lawyers make up nearly 99% of all private practice lawyers. And guess what? The small guys aren't typically competing against the big firms. They're competing against each other. So it's no wonder that the average marketing budget for solos and small firms as a function of gross revenue is much higher than the ratio used by the large firms. Legal marketing for small firms and solos has become a bit of an arms race. I buy an ad, a big ad, and my competitor down the street buys a bigger one. I'll tell you a story. About 8 or 9 years ago, I bought an ad in Arizona Attorney Magazine, which is the monthly bar news that is sent out to all licensed attorneys in Arizona. The ad essentially said that I love my practice and asking for referrals and so forth from non-competing local lawyers. Before I placed that ad, there was very little to no attorney advertising going on a regular ongoing basis, although certainly there were certain feature additions that did have room for attorney marketing. That ad got me a lot of attention and it got me great returns. In the first 3 or 4 months, it created about a dozen good referral sources that continued to feed cases into my practice for years after that initial advertisement was taken down. But after a few months of running that ad and getting this great attention, copycat ads from my competitors and from other lawyers around the state started popping up in that magazine. At that point, the arms race was on, and I quickly withdrew my ad. Because I was first in, I made a great return on that investment. In fact, each referral that I would get as a result of that ad paid for roughly the first 4 months of running that ad and then some. For me, that marketing was a fantastic return on investment. It was sky high and it created lasting goodwill because it was novel and made an impression. I doubt that those who came after me into a now crowded medium did as well. Yet many of them that started at that time persist to this day, presumably flowing a healthy stream of revenue to the state bar's publication. My assessment of ROI, or return on investment, for that marketing might be very different than some of the lawyers who came after me. I would not have been happy with a 4-to-1 or even a 10-to-1 return on my investment. I wanted many multiples of that. I would make small, calculated bets based on marketing opportunities, measure and monitor them, and withdraw not when my return had diminished completely, but when it diminished in a measurable way over a long enough time due to factors that were not likely to change in my favor. Other lawyers measure return on investment by simply saying that if what I put in is generating as much or more money than I'm spending, then it's worth it. What this fails to take into account are the opportunity costs of the time or money that could be better deployed elsewhere and the efficiency of the business generation mechanism. A necessary part of understanding the efficiency aspect is knowing with relative certainty how much it costs you and your firm to work the case that the marketing creates. And you have to assign a value to your time as the primary attorney in the firm. Everybody's time has to have a value. There are many additional layers on top of this, but this is as complex as we're going to get during this webinar. The idea is to get you thinking holistically about your practice, not only about your cash flow, but about your time flow as well, which brings me to this. There are really only two kinds of resources that you can invest in growing your practice. One is your time, the other is your money. If you have employees, their time is your money. If you have expertise that you gain and bring to bear, that's your time. If you outsource anything, that's money. When you think about what your time and your money mean to you as an attorney, you'll realize that the valuation of each is fluid over time. So, for example, when you're a young attorney or when you're just opening up a new practice, you probably have more time than money. When you're busy and established, you have more money than time. If you feel like you lack both at the start, you're starting from a deficit that is going to be hard to overcome. This is because you should always put a value on your time, always. When you treat your hours like you treat those of an employee and quantify the value of that time, it can open up a whole new world of thinking that can put you in control of your business. And rather than reacting and just getting things done, you'll actually be building your business. If you're not aware of the time you spend on your business activities and the relative value of that time, it's impossible for you to quantify your real return on investment for anything that you do. especially your marketing. We've all had cases that we miscalculated, that we undercharged for, or with difficult clients where the time drains were such that we ended up netting $5 per hour by the time the case is over and the work is done. If you accept a flat fee, say of $1,000 in a case, and you end up doing 200 hours of work on it, your nominal hourly rate in that case would appear to be $5 per hour, right? Well, not so fast. In reality, that $5 for each lost hour is your consolation prize that offsets your lost opportunities and time. When you start thinking about your time and your money together, it might make you queasy to think that case didn't make you $5 an hour over 200 hours. It actually cost you tens of thousands of dollars in missed business and perhaps tens of thousands of dollars more in assets and infrastructure that you could have spent time building in your business. While you were toiling away thinking that you were making $5 an hour and probably pretty upset about it, you were actually losing hundreds of dollars an hour or worse. That's the secret that attorneys who are really successful in the business of law understand. You have to step back and think strategically. Either you're acting and thinking like a CEO of your law corporation, or you're just a player enmeshed in the drama of the day-to-day. So keep in mind that every minute you spend has a financial value or a cost. Are you squandering it or building assets that appreciate? A lot of lawyers rush into marketing and make poor decisions because they view marketing as either beneath them or a waste of their time to spend much time thinking about the various options that are out there. I'm going to give you a few simple questions to ask yourself as you consider which marketing investments to make with your time and your money. The first question to ask yourself is whether the expenditure is really an investment in an asset or is it just a disposable expense? An asset is something that has value beyond the moment in which it is consumed. An expense is a one and done proposition. When you build assets, it's like creating marketing robots that you send out in the world that keep working for you over time without cost and without complaint. Their value may even appreciate over time. A marketing asset is something that has value beyond the time you use it in your practice. In fact, if created consciously, it's even something that you can sell when you close your practice because it will have value for other lawyers as well. In fact, I've sold marketing assets that I created when I closed my Seattle practice and moved to Arizona. And I also sold my marketing assets when I closed my Arizona practice after my first technology business took off and I realized that I was going to be going into legal technology full time. I'm a firm believer that if you spend your time and money on marketing that is not in some way contributing to building an asset, then you're throwing money and time away and dooming yourself to being on a treadmill that you'll never fully escape, and that oftentimes, as business ebbs and flows, feels much like a roller coaster. Let's look at some expenses that in and of themselves don't really appreciate or build equity. While there are case-specific exceptions and arguments against what I'm saying on a micro level, and I'm sure I'll get some nasty grams from all the billboard salesmen that have snuck into this live session or who watched on demand later, but the thinking goes like this. You buy a TV commercial, you run it, it's done. Either you get calls or you don't. Either those calls turn into clients or they don't. If you stop running the ads, the cumulative effect goes away very quickly. For example, say you practice divorce law. You get talked into buying a 30-second radio spot during drive time. Say it's supposed to run 4 times a day for 2 weeks. During those 2 weeks, it may or may not produce business. But at the end of those 2 weeks, when the ads stop running, it's unlikely that there will be any measurable lasting effect from these commercials. As professionals, very few lawyers have iconic, memorable, unforgettable brands. You are unlikely with your law firm's brand to seep into the mass consciousness unless you spend money on disposable media such as radio and TV over a very long period of time and have a very memorable, emotional, meaningful message that's very distinct from your competitors. Even if you spend millions of dollars a year, say this year on TV ads, 2 years from now, after you stop running them, what value do they really have for your firm? The answer is probably not much. I'm not saying that you shouldn't buy some disposable marketing, but do so with caution. How many lawyers have you heard say something like, I work for the phone book, or I work for the marketing company that I'm in contract with because all my returns are basically going to them? How many pens with attorneys' names and logos on them? How many sticky pads with their embroidery or coasters branded to a lawyer's firm have you or anybody that you know of kept long term? How many of these types of marketing collateral pieces would, even if you kept them, drive your decision to engage a professional for services today? Would it make it more likely for you to engage an accountant because you had a calculator with their name emblazoned on it? The reality is that it probably wouldn't, with all of the more complex, more interesting digital marketing messages that we get every day in this modern age. So ask yourself, is this just an expense, or is it bolstering the value of an asset? Let's talk about assets and how to build them. Think about things that have life beyond the moment and that could be useful to others beside your firm. The list in this slide is far from comprehensive, but encompasses what we view as the most versatile and easiest to produce and maintain types of assets in today's technology and economy. Think about this. When you buy a pay-per-click advertisement, say that click cost you $35 to have a single visitor go to your website. That single visitor may or may not become a client, but that $35 is gone forever as soon as that click happens. Contrast that to building a new page of content on your website, written with quality information that the public, especially your potential client base, wants to read. That is an asset that can keep producing clients for years to come. And done right, it probably costs about the same as a couple of clicks. This is what I mean by asset. Once created, they remain in play. Not all assets are good, though. You want assets that are future-proof and that will appreciate. Good videos, good blog posts, web pages, engaging infographics are all good examples. Beware of potentially toxic assets, though, and we'll get into these a little bit more in a few minutes. The other consideration is whether you're creating value in an asset that's truly yours or an asset that somebody else owns. There are many legal marketing outlets that leverage your hard work, your content to build their brand, their infrastructure, their assets. Be careful when you invest your time and your money, because when you invest in something that you don't own the rights to continue using, or that somebody else can repurpose without your consent, you're working yourself towards the business equivalent of a Darwin Award. More on this in a moment as well. We all know what happens when banks build up too many toxic assets, and then the market for those assets freezes up. There are a lot of marketers out there who have been selling toxic marketing assets to attorneys for years. The internet equivalent of a toxic asset freezing is a search engine algorithm update that activates a negative consequence because of the existence of a toxic asset. For example, attorneys have been paying SEO people to get them inbound links and even paid for links from websites that sell them for years now. For years, this has been against Google's guidelines, and yet the market keeps selling them because, well, it worked for a time. For years, SEO companies have been talking their clients into buying these things, taking them for a ride on the ups and downs of link building, which amounts to a roller coaster of success and then abject failure, and the ensuing link penalties that come as a result of engaging in these practices. The links would work, then they wouldn't, as Google worked on perfecting its technology to eradicate them. Just last month, many lawyers woke up to a new and sobering reality that all the money that they had invested over years and all the time that they had invested in building up a link profile that they thought was an asset had caused their web ranking and their traffic to plummet off the radar. Some businesses were hit very hard, but one could argue that their previous good ranking, built on a toxic linking profile, was a product of market timing and, in a sense, irrational exuberance. They might be upset that the good times are over, but the writing had been on the wall for years, and they had been buying something that if they had done a little bit of research, they would have realized was not in their best interest. My point is this: many marketers won't tell you that they're selling you toxic assets. Some don't even know that what they're selling you is wrong. Some are just glorified middlemen with scripts and a hunger for your firm's money. You can't rely on anybody to tell you the truth about your firm's marketing. You've got to spend a little time educating yourself and investigating the alternatives. The fact that you're listening to this webinar means that you already get that point. But I want to emphasize that if something that a web marketing person says, even if they're from a big and storied legal marketing company, if what they say doesn't sound right, then there's probably a reason. If you can't understand their explanation in simple terms, then there's probably more to the story than meets the eye. Never take what a salesperson says at face value. It's okay to trust after they've earned it, but verify first so that you don't end up with a portfolio of toxic internet assets that can and eventually will bring down any part of your practice that depends on the internet for business. A lot of lawyers don't really consider the implications of what they invest their time and money in. I'm amazed at the fact that many lawyers spend as much or even more time answering questions and contributing to forums and directories that they don't own than they do working on their own websites, blogs, and social media. The second you answer a question on a shared forum or directory that you don't own the rights to, that answer that you wrote starts working. It might do a little work for you and your firm, but that work is done at the pleasure of the company that actually owns the directory and the content that you submitted to them. Your hard work and content can be used to lure people who are interested in what you write to your competitors. It can be used to sell ad space. It can be used to justify raising the price that they charge you to keep your name on or near that content that you have produced. On the other hand, when you own the property and contribute to it, no one can ever take that away from you. And here's what you need to own at a very minimum to make sure that you're protected. You need to own your domain name. To own your domain name, that means that it's registered under your name, that you have title to it. You have registrar access, meaning a company like GoDaddy or Enum or register.com where you can manage it. And you've got to make sure that there are no encumbrances on transferring it. Encumbrances would include you registering it through a webmaster that keeps control over it. I want to be very clear and very adamant when I say that it's so important that you control access to your domain, because without that, you have nothing, and it can be taken away from you with a click of a button. The other thing that you need to make sure that you own and have control over is your content. Never, ever rent content. Never agree to pay a company to produce content for you that you don't get a copyright to and have exclusive rights to use however you please. You may change web service platforms several times during your career, but as long as you own your domain and your content, you'll never lose a thing, and your work, your time, and your money that you put in will benefit you and only you. I want to take a moment and talk about owning the technology of your web properties, such as websites and blogs, the technology that it uses versus owning the domain and content, because these are two separate and distinct concepts. The way that today's technology is evolving, in 2 years from now, all of today's technology will be obsolete unless it continues to evolve with the pace of the internet. Lawyers who buy static websites that they own or buy a blog that is made for them, that they simply take possession of the technology, have really two future ways to adapt, and neither of them are ideal. The first is that they can learn to program and manage the technical aspects of their internet presence themselves. They can learn how to do WordPress updates, patch plugins, do security checks, update other database issues, stuff like that. Or two, they can pay somebody to maintain what they have, and inevitably they're going to have to pay somebody to rewrite the code and redesign the look and feel as the internet and the way that we browse the internet and consume information changes. Think about 5-6 years ago, before touchscreens and tablets were a reality. The internet and the way we consumed it looks very different today than it did, and that's a slow evolutionary pace compared to how it's evolving today. So I look at owning the technology that's frozen in time as foolish ownership. Owning your website code can be a toxic asset that not only depreciates at an alarming rate due to the evolution of the internet around it, but can also become outright dangerous. If you bought a website 3 or more years ago and it hasn't changed, there's a very good chance that you've already felt a decline in your business, or that you soon will. The only way to truly keep up with the evolution of the internet in a cost-effective way that ensures that you're always on the cutting edge of technology is to use a hosted, managed technology, or cloud-based technology, as it's sometimes referred to, such as the LawLytics digital marketing system. LawLytics, for example, includes automatic updates to both the backbone technology and the look and feel of your websites and blogs to keep it optimized. These updates happen incrementally, so you never build up a debt of obsolescence. Despite being on a managed platform of code that you don't own the code base, you do own your domain name and you do own your content. The important thing is having clear title and portability, which you have. Now, I want to make this absolutely clear because it is confusing to a lot of people. With LawLytics, and I'm speaking to both the current LawLytics customers who are viewing this webinar and the ones who have joined us from the public who are not LawLytics customers. With LawLytics, you own your own domain name. You own all of your content. All of it's portable, and you always have the choice to, at any moment, to migrate to another platform. And that's how it should be. No matter what platform you are, LawLytics or anyone else, you should be able to take your web presence to another provider at a moment's notice, and you should never be trapped by ownership or contractual issues. If you sign a long-term agreement with a marketing company, you may still nominally own your website and content depending on what that contract says, but that company that you're now contracted with owns you. for the duration of your agreement. It comes down to control and who gets the benefit. You, as the attorney, should always have both, period. Now, during the introduction to this webinar, I told you that my early experience with an unethical SEO company started me thinking about what is real and what is an illusion when it comes to legal marketing. I wanted to know what kind of returns were realistic to expect. I wanted to discover a bright line rule that could tell me exactly when something was too good sounding to expect it to be true. My conclusion to this date is that there is no hard and fast rule that we as lawyers can apply like a formula to determine what is in our best interest and what will provide the best return on investment over both the long and the short run. Instead, there are a bunch of what I'm going to call mini rules, for lack of a better way of putting it, the sum of which I believe give lawyers the best chance of getting the best results. And here they are. Rule 1, and I'm sorry this has gone a little longer than we expected. We probably have another 5 or 6 minutes or so left here, so I'll be wrapping up shortly. First of all, you'll never be able to measure everything that goes into your firm's true return on investment, and that's okay. There's still plenty that you can measure. Be a curator of data. The more of it you have over time, the more you'll be able to see trends and discover small pivots that can make a huge difference. A lot of lawyers defer thinking about their marketing because it's difficult, especially when you're first starting. And when they make a choice, they oftentimes do it when the pain of not making a choice reaches a critical mass. Don't make this mistake. And hang up on every salesperson who pressures you to buy right now because there's either a limited quantity or there's a deal that's going away or whatever. Pressure and reactiveness are the number one enemy of getting the return on investment you want and deserve. Don't get trapped by predators. They're out there, lots of them. And there's no reason you should ever have to commit to any marketing program for more than a month or two. Incidentally, you should avoid buying any marketing product that takes a long time to build. With modern technology, including LawLytics Attorney Marketing Suite, basic websites can be built and launched in literally hours, and complex builds and imports can be done in a matter of days. With today's available technologies, if you commit to something that is going to take even a month to build, you're putting yourself at a disadvantage because you're paying for something that you now have to wait to test. In the interim, you're deferring both those results of the tests and the results in terms of clients and business into your firm. The only way to learn is to experience. There is no good academic path towards mastering the numbers of growing a law firm. Look at finding the right way for your firm as a journey, and it begins with the single step of giving yourself permission to get in and to get lost. Now, this doesn't mean that it's okay to just blindly commit to something. Take baby steps, make small bets, test them, make adjustments, and stay present in your firm's growth, and you'll quickly find your way. Don't let a marketing salesperson push your greed buttons. We all know what's going to happen to this guy on this stack of coins. Don't be this guy. You don't need to become an expert in any of this. There's no reason for you to have to know programming. Help is out there. All you have to do is know what you don't know. Be comfortable with that and seek out people and resources to supplement your knowledge gaps and the gaps in your time, for that matter. Don't fall for the BS that some marketers try to sling. There are no special alliances that any marketers have. So the next time a marketer calls you and says, quote unquote, we work with Google, implying that they have a special relationship, understand that they're full of crap. If somebody tries to sell you a secret formula or special relationship, a simple one-word response will save you a lot of money and frustration. That one-word response is bullshit. For the really persistent ones, you can use a two-word response said slowly and clearly. Bullshit. Don't get analysis paralysis. There are too many things and too many data points for anybody to master all of them. Think about what is useful to you and your practice. If you're collecting as much data as you can always double back and learn more from that data later. But don't let the fact that you haven't figured everything out yet prevent you from getting started, from getting launched. Rule 9 is just another way of saying Rule 8, but it's so important that it bears repeating. Way too many lawyers have some version of this under construction notice on their websites. Some have it for years. As long as you've paid attention and not fallen for any of the traps that the other rules are designed to avoid, the worst thing that you can do is do nothing at all. Don't accept excuses from a webmaster who just can't seem to get your site launched. Don't create excuses not to launch a site because the pictures or colors might not be perfect. With the technology that exists right now, you can literally have a beautiful, mobile-compatible website launched in days. Every day that you wait is a day that, one, you're not collecting information, and two, that somebody else, one of your competitors, is connecting with those clients that you're missing. Don't be afraid to ask for help before what happened to this guy in this picture happens to you. Nobody is an island. Get the help you need early and get it often. Ask lots of questions. Engage your vendors. Engage your peers. There's a robust community of knowledge and help out there. Use it. Finally, don't sacrifice the long-term health and profitability of your law firm for short-term gains. That is, unless you're on the verge of retirement and the time horizon doesn't really matter to you. Building marketing assets that appreciate is now universally accessible based on the modern technology. Don't get distracted with things that are merely expenses, and always ask yourself, does this serve the best interest of my firm, of my family, and of my clients in the long run? If the answer to all three of these questions isn't an unequivocal yes, there's a substantial chance that you're just creating more expense items or more toxic assets. Now, I want to conclude by doing a little prelude to next week's webinar. The most effective investment that you can make of your time and your money is in creating content that resonates with your clients and potential clients. This is important whether you're a LawLytics customer or not, and is with each passing day as the technology evolves, getting more and more critical. Next Thursday's webinar is one of the most important of the year. Kit Kramer, JD, our Director of Marketing, will be teaching a session about writing for the web, which is very different than the writing that most lawyers are used to. I hope you'll join Kit for a practical half an hour that you'll be able to put to work in your practice immediately. Thank you for attending today. If you have questions about what we have discussed, we'd love to talk with you. Please shoot us an email or give us a call.